Hey everybody, it's Caroline. Today we're going to talk about those small print areas in your contract, the parts that your eyes kind of glaze over and you don't really know what they mean, but they're really important building blocks of basically any single contract you sign, or at least they should be. If they're not there, we might want to put them in. Uh, these parts of the contract may tend to be towards the end, um, but that doesn't make them any less important. Now, what parts of the contract am I talking about? Things like the recitals, indemnification, modifications clauses, all of these pieces we're going to talk about today to explain what they mean. And knowing that they're probably going to be in almost every legitimate contract you sign can really help you out in the long run. So let's dive in, let's get started and make this as painless as possible. First, we have recitals. This is actually the only thing in the beginning of the contract that I'm going to talk about. Everything else is going to be typically towards the end. Recitals are essentially setting your stage. It's not dancing on stage, it's setting up the contract for uh, the rest of your reading of such. So we're establishing the businesses or the people involved, the parties involved. You want to use everyone's full legal name here and provide full addresses. If you are working with a single client, one person, you're just going to include that person's name. But if you're working with a couple, you're going to want to include both of their names. Or maybe you're working with a person and a business. You're going to want to include that. And you're going to use those legal terms jointly and severally as well. Those actually mean things. So we typically like to see that. Now moving on to the end of the contract. In your contract, you're typically going to see this indemnification clause or something very similar. Indemnification means I'm going to cover your costs, legal fees, and expenses for any number of enumerated things. Typically, those enumerated things, enumerated actions are going to be something like, party A told party B something, or made some sort of promise to party B, or assured party B of something. If party B gets in trouble because of that, party A agrees to pay their legal costs and expenses. Here I have, if the client or the couple says something, or any of the guests at the party sue the photographer, the client agrees to indemnify, defend, and hold harmless that photographer. So the client would then pay for the photographer's legal fees or expenses or costs that arise out of that lawsuit, because the photographer is really just doing what the client said to do or wanted them to do. So when you get back and forth on indemnification, it can get a little sticky and it can get a little confusing. So this might be an area, if you have clients pushing back, that you want help on from a lawyer. But knowing what it means and knowing what you are agreeing to or what you're having your client agree to can go a long way when deciding if you want to change this clause or not. Next, we have what's called the entire agreement clause. Sometimes if I'm trying to shorten contracts and make them not so long, I'll mush this together with modifications. So I'll talk about that in a second. But focusing on the entire agreement part, all this means is that every agreement about the services and about what we're talking about in this agreement is contained in the four corners of this document. Nothing said or agreed to outside of this contract counts. If you want it to count, it needs to be in the agreement, not in an email, not in a phone call, not in a text message. And this is really important if push comes to shove or things get messy, because we really want to have everything we've agreed to on paper, right? So that's why we include these entire agreements clauses in the document. Now, switching to that modifications clause, if we need to change something or add something to the agreement, we have the ability to do so. However, it needs to be in writing. Now, we used to say modifications can only be made in writing when signed by the parties. But due to the digital age and the fast paced nature of event days, I usually like to put something in there that says, or confirmed in writing by email by the party accepting that modification. So basically, what that means is, hey, you send an email that says, we're going to change this. The other party or the client, whoever, says, yeah, I agree. They email you back and say that. That can also be an effective way of modifying or changing that agreement. Next, we have an assignment clause. Assignment just means transferred, uh, switched out. So all you're saying in an assignment clause is this agreement can't be switched out. The one person can't switch out another party to perform their obligations. The client can't assign another client. They can't switch it to someone else. Nothing crazy, but also pretty important to have in a contract, because you don't want to just have some random new client that is subject to your agreement. So that's why we include an assignment clause. The next clause we're going to talk about is severability. This might be referred to, or you might see it talked about somewhere in agreement in certain states, as blue penciling. It is called that colloquially. Severability means, okay, if one portion of this contract is declared invalid, is not enforceable by law, because sometimes there are certain clauses that have been deemed to be unenforceable for public policy reasons, that clause will just be completely nixed, completely stricken, but everything else will stay in full force and effect. We're not canceling the entire agreement just because part of it's unenforceable. There are some states that will cancel entire agreements just because one clause is unenforceable. So this is important as well, and why we include a severability clause. Next, we're going to talk about the waiver clause. Waiver just means, hey, because I let something slide once, doesn't mean I'm going to let that slide in the future. So maybe a client pays their fees late. You have a waiver clause that says, hey, just because I let you pay your fees late once, that doesn't mean you can do that again in the future. That doesn't mean you can rely on that ability to pay late in future payments. Next, we have the notices clause. Notices is really important when we have disputes. I mean, there's no two ways about it. You want to be able to send legal notice or written notice or any sort of notification about the contract to the person in the contract and have it become effective at a certain time. So they can't dodge it. They can't say, oh, I never received it. And you also want to make sure you know where to send that notice. That's why in the recitals, we have everybody's address. And that's why it's important to make sure you've got your client's address in your agreement. But it runs both ways. You need to make sure your address is in there and your address is kept up to date. So typically we will have notice has to be certified mail, or sometimes we can have, okay, any notice has to be sent by email with confirmation of receipt. That's another way that you can put notice in an agreement. It really just depends on what works best for you. But it's something we want to have to make sure that if we are sending lawsuits or we are sending cancellation or termination agreements, they are effective, which means they take effect. Next, we have attorney's fees. Now, this is one that really surprises people, but you cannot get attorney's fees. You can't recover your attorney's fees or your costs or expenses for suing someone unless one of two things is true. One, it's written into a statute somewhere, so it's written by law that you can get attorney's fees. And there are laws that happens. Copyright laws can be one of them. A lot of employment laws are like that. Or it's written into a contract. If it's not written into a contract, you do not get attorney's fees. So if your client doesn't pay you, $2,500, they don't pay you $5,000, and you don't have an attorney's fees clause, you can sue them for that amount, but you won't be able to have them cover the cost of your attorney, which can be very expensive, and it can make it really unreasonable for you to sue to recover that amount of money. So that is why you will see this included in contracts, because if it's not in there, you probably can't get it, which stinks. All right, final clause is governing law, jurisdiction, and venue. Governing law is what laws are going to govern how we construe this contract. As you know, laws from state to state, country to country, they can be very, very different. We want to make sure that if we sue somebody, we are governing them with the laws of our state. We also want to make sure that who we're suing has to come to our turf. They have to come to our state, our city, our county. So that is why we include jurisdiction and venue clauses. I'm not going to get way too far in the weeds with all the legalese and jurisdictional arguments and constitutional law and civil procedure here, but just know you can pick your jurisdiction and venue typically. So we include the governing law, jurisdiction, and venue to make sure we know exactly how this contract is going to be construed, where lawsuits have to take place, and where we can be sued or we can sue our clients, womp womp, in a worst case scenario. Last little thing I want to talk about, so important, and I see it wrong all the time, mostly because of technology limitations from CRMs like Honeybook, Dubsado, Pixie Set, and it makes my little heart cry, but you're going to know now. Make sure you are signing your contracts as your company, okay? If you are a company, you need to include your company name, your full legal name, and then you're going to say by your name and your title, because that shows that you're signing as your company and not as a sole proprietor. Because remember, if you are an LLC, if you're a corporation, you have that limited liability bubble that protects you. But if you are not being clear that you are signing as your company, that bubble goes out the window. So we want to make sure every time, make sure you're signing as your company and not as your personal self. Second thing to note, if you have a couple as your client, you need both of them to sign the agreement. Both of those people to sign the agreement. I'm not going to go into third-party payers. If you're interested in third-party payers, we have a lot of good resources on the blog. We also have a third-party payer agreement. It's a whole nother ballgame. But whoever is the client, whoever's your couple, whoever's paying, whoever you want to be able to direct you and to have say over your services has to be a signatory on this agreement. They have to sign it, okay? So get both of them to sign this agreement.